All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV21-0336, Bergevin versus Bergevin. Each side has 20 minutes to present their argument. Appellant may preserve some time for rebuttal, but I ask you to do that yourself using the whatever clocks are on that side. Our proceedings are being audio and video recorded, so if you could introduce yourself and your client at the beginning of your argument, that would be appreciated. We have read the briefs and discussed the case this morning at conference, and we're familiar with the arguments that are raised, and so I would just ask you keep that in mind when making your arguments. And with that, counsel, you may proceed.
Thank you. May it please the court, Keith Berkshire for the appellant, Mandy Bergevin. Got to apologize for not wearing a jacket. I just had elbow surgery and this thing won't fit through.
I'm sorry.
This case presents an interesting legal issue as to whether somebody who has significant resources can take a very large portion of their net worth and put it into an asset, essentially an investment account, which would take it outside the realm of being available as a resource for child support.
Counsel, was there evidence in the record that that was the intent, that the father in this case intended to hide or park assets outside of the court's control?
No, there was nothing in it from that standpoint that there was any sort of malfeasance, that this was the actual purpose of it. But whether it's the purpose or the result, I'm not really sure whether it matters. When you look at the child support guidelines, obviously under Section 5 has this concept of what is income, which is a very broad stroke definition. But the guidelines are based actually upon the statute, and the Supreme Court creates the guidelines, but they base those upon ARS 25320. 25320 in doing child support does not reference income. It references the financial resources of the parties. And so the context of what Section 5A, as far as what is considered income for child support purposes, has to be looked at under the overriding statute, which is what are the parties' resources. And the reason I bring this up is when we look at the prior case law from this court, and the main case that most of the other cases, the progeny we talk about, most of the income cases, or what is the additional income, all starts with the Cummings case, which was a concept of where the grandparents were gifting money to their daughter, and the argument was that within the realm of consideration for lowering child support, because mother was receiving child support in that situation. Should it lower it because she has these recurring gifts? And what Cummings stated, and which is the quote that has, made its way through all these other cases, is the quote out of Cummings, which is the court should focus on actual money or cash-like benefits received by the household which is available for expenditures. This is the most common quote that this court in Division 2 have both used when it looks at what is income. So actual money or cash-like benefits received by the household which is available for expenditures. And when we look at the progeny of Cummings, things like Milinovich and the Sherman case, these all use that same exact analysis, which really ties what the guidelines...
But counsel, I think there's an important sort of clarification in Sherman, and that also represents a thread through the cases where, Judge Swan pointed out, the question is whether the parent acquired a source of funds for living and personal expenses from which the children would have benefited had their parents not divorced. And I think there is a distinction in the cases, the loan there, the gifts, when the question is the availability and the regular use of a source on an ongoing basis for daily or monthly expenses. And we don't have that factually in this case. Isn't that an important distinction?
I think it's a distinction, but I think it actually is a distinction that actually, especially in light of the Sherman case, actually goes in our favor here. I mean, Sherman of any case, I think when Sherman came out, I think it caused a ruffle in the family court community of this was a loan. I mean, this was, yes, I mean, the guy was disabled, that he's borrowing money, I think it was from his brother or cousin, I can't remember exactly, but he's borrowing money and they're saying, hey, you're pulling out X dollars a month from this loan, that's what you have available for resources. So,
But the court was also concerned there with the fact that the father had not shown any change to his lifestyle, that it's not just that he was using this loan, it's that he was using the loan to maintain a certain standard of living. It's not certainly sympathetic, as you point out, but not quite so drastic, I guess.
well, I guess I get that, and I understand the concept that he was using, the court really basically attributed what he was pulling out per month, which is the same as what the court did, the trial court and this court did in Milinovich, Womack, which was what are you spending a month? Obviously, that's what you have available for resources. But here, if we look at it, let's take a hypothetical where somebody has a bunch of resources and pays off all their debt, buys their house out in cash and does all this, maybe not spending the money, but has used a significant portion of their resources to reduce their expenses. They still had those resources. That's the situation here. This isn't somebody who has, $5,000 being contributed to their retirement account from their employer. This is somebody who took $12 million and put it into, it's not a retirement account, first off, it is an annuity. It's a life insurance, actually, investment account. It's not a 401k, it's not a pension, it's just a life insurance program. That somebody took that voluntarily, it's still there, they can still tap into it. He's tapped into it to the tune of $2.5 million over the course of the couple years that were looked at here. It still unquestionably fits the statutory designation of that it is a resource available to him. It's not outside this, it's not in some islet or something else that he can't touch. He can touch it anytime he wants. He chooses to touch it for his businesses, just not for the child at issue in this case. And again, I think the slippery slope problem with it, and I hate to make those arguments, but the slippery slope problem is you could have a situation where somebody has massive resources and chooses to just, again, reduce their expenses by paying off everything they have in cash, paying everything where they have no monthly nut, because they use their resources to do that. And that's essentially what's happening here, is that you have somebody that's choosing to use his massive resources, pushing $35 million, according to all the testimony, and choosing how to invest it. If we just took this from a Merrill Lynch account with $12 million into it, returning regular investments versus this life insurance thing, let's say he's not using either of them. One of them would unquestionably be counted because it has capital gains. The other, just because it's designated a different type of investment, is not. That's the issue, is they both are resources within the statutory language.
Isn't there, though, still a problem? Let's assume even if the court had counted this as gross income, mother still bore the burden of establishing the amount of child support. And Judge Coffey was pretty explicit in noting that there was very little evidence presented on that point, and he walked through the other sources of, I suppose not in the traditional sense child support, but support that mother was receiving, or at least that the children were receiving from father. So to the extent that the judge was fulfilling the intent of the statute to provide for the child and to provide the reasonable support necessary for the child, didn't mother sort of fail to prove that there would have been any difference anyway?
Well, I obviously saw this question coming on, having been here a few times. The issue, I think, is it's hard to know. I mean, that really gets into almost a harmless error analysis, Judge Perkins, because you're saying, let's say they did err. The error is on factor 1 of 320D, which is the resources of the parties. If the court misconstrues the resources by taking his income down 70%. I mean, this is, the court used, high 200s versus the mid 700s. So if the court misapplied to the tune of only using a third of his income, which of the actual income, it's hard to say how that would be a harmless error, which is what you're basically saying was, okay, well, she didn't prove up a number, but the starting point was to know the resources. Factor 1 is to know the resources. And if the court misapplied that, we don't know, because with the number the court used is barely actually outside. It's actually not outside the new cap for child support guidelines that just went into effect of $30,000 a month. But under the old cap of $20,000 a month, his income was barely outside that range. That's barely into where the judges start looking at this. Versus if they said it was $66,000 a month, which is what the Brandon Kennedy, the court-appointed expert, said, then I think the analysis, we don't know if the analysis wouldn't have been different because it's such a massive difference in the income. You're talking tripling it.
Let me ask you, counsel. So you're describing a two-part inquiry with a firm line in the middle. And the first one seems untethered to the child or the child's best interest. It's just an accountant could do it in a room, and then we'll walk into the best interest room, and then we could ask how much is needed for this kid to maintain the life. And we look at all of these how we've defined support, how the legislature has defined. Is that what this is, a two-part exercise? In the first room, no one utters the words best interest of child?
I think if you look at the factors under 320D, I think that is. I mean, resources of the parties are irrelevant. I mean, the parties could have $10 billion and live in a trailer. I mean, that doesn't mean what their lifestyle has been during marriage and so forth. I mean, I think the first part says, I mean, there's very specifically delineated statutory factors. The resources of the parties, what also gets into the needs of the child, the resources, what would have happened if the parents stayed together. So I think from your two-step analysis, I think it's actually more than two. But yeah, the first one is they have to determine the resources. And so the resources so implicitly go into what the parties' lifestyle that I think you can't get to the next step if step one is off by that amount. I think if it was off, $40,000 a month versus $42,000 a month, I think the analysis of, okay, maybe it is more harmless error because the guideline amount wouldn't be that much different. But here it's off by massive factors. And I will point out one thing that it was quoted in response to in the testimony for Brendan Kennedy, but their father basically testified at his deposition, which was quoted in the transcript, where he said if his income didn't change, there should be no change to child support. So and this was quoted during the Brendan Kennedy's testimony, so if that's the case, if the court found that his income didn't change, which actually our position at trial, I was trial counsel, but the position at trial was that it went up. And if you look at the old stipulation, the old worksheets, if it went to $66,000 a month, it went up. So under father's own testimony at his deposition, if we find factor one that his income went up from last time, and adopted Brendan Kennedy, then his own testimony at the deposition was there shouldn't be a change in child support, so that it doesn't even need to go to the deviation language.
There's a little bit of difference here because the initial child support amount was something the parties agreed on, so it's not as though there was a court-ordered child support amount that went through these calculations, and then this process of determining possible changes in income one way or the other, and then a deviation taking into account. That first amount was something the parties agreed on. They agreed it was temporary, and they agreed it was subject to later evaluation by the court, right? Isn't that something a little bit different?
Yeah, and I think it is, Judge Perkins, but I also think it then gets into like the NIA analysis that this court did a couple of years ago, where you have to show the change first, and then the burden shifts to what to proving up the deviation. Our position is if the income didn't go down, we don't get to step two under NIA. So they have to show a change in circumstances first. Here, father's argument was that it's massive reduction of income. So if we have no reduction of income, if the court used the right number and considered all his resources, we don't get to step two because there is no change that would justify re-looking at the deviation. You only get to look at the deviation again. There has to be a change first. And father's own testimony, his deposition was, if my income hasn't gone down, you're right, there's not a change. So that lines up directly with NIA, where to get to recalculating this, the income would have to gone down or something else in father's favor. If his income went up, you don't get to that. So that's the important part here where, yes, you could say, okay, maybe she didn't, let's say she didn't prove the deviation. But again, we should have never got to that step because the first step is considering his resources.
So if the court's goal was to, and I guess this is Engel versus Landman, the overarching purpose of the guidelines is to establish support for children consistent with their needs and the ability of parents to pay, and to make child support awards consistent for persons in similar circumstances. If that was the driving factor for the court in what it included and didn't include in this, in the exercise to figure out income, how is that error?
Well, I think two things out of the quote. The ability to pay, you'd have to I mean, you have to get to their income, the ability to pay. And the last part of that quote.
Which comes after needs.
But the last part of that quote was also in line with other people similarly situated. Again, if you're saying he makes a third of what he makes, you're not comparing him to people that are similarly situated, because you're saying he makes $250,000, or I forget the exact number, but somewhere around there, versus $770,000. So again, the starting point of all these and all the analysis has always been, what are the resources of the parties? I mean, it's the first thing you put in the worksheet. It's the first thing in the child support guidelines. It's the first thing in the statute about this is, what are their resources? So if you start from an improper position that we just have a wrong number, then you can't do the rest of the analysis properly.
So it is a wrong number. It's a mandatory inclusion of annuity?
Nothing is mandatory. I mean, this gets into the argument of, is it discretionary in the may part of the statute? Well, it's discretionary to the point that it's legal error. I mean, if we look at the case law on this, I mean, we go back to cases like Hetherington and Patterson and all these things that, I mean, Patterson added in the guy's on-base housing value into his income. Hetherington added in the retirement contributions that the company made on his behalf. They added in whether his health insurance was paid by the company. They add all these things into what their income is. So Sherman adding in the loan proceeds, Milenovich, which is the most similar case to this, we think that it's just an investment strategy. All these cases had very broad definitions of what could be completed resources.
Paragraph 5. So this is the guidelines. Mm-hmm. These are the first 7 words. Gross income includes income from any source. Is that permissive or mandatory?
I think it's, I mean, it doesn't have a shall or a must, but I think includes is a directive.
Right, and then it's followed by may. Do you have it in front of you?
Yep.
And so, are you interpreting that to say that gross income is a certain figure, but from case to case it'll have different parts? And you might see an annuity, you might see this. Is that how because that's a mandatory.
The word may appears in the guidelines. I don't doubt that. But it also then says may include salaries. I don't think anybody's going to argue that somebody's salary shouldn't be included in child support. I mean, if to read it that openly that it's discretionary would say may include salaries, wages, commission, bonus, dividends, all those are discretionary. None of our case, I mean, the case law in child support is really broad. I mean, the court has really gone out of the way.
Let me ask you in that, what is the best case that you would point to for a sort of non-salary, a comparable or an analogous pool of money that was not previously being used by either party or relied on by either party for ongoing expenses, housing, healthcare, those kinds of things? Because I think that's one of the difficult things here is that this, although the father did pull out twice chunks of money, there was no evidence that this was being relied on as a regular source for those expenses.
Well, we don't know. I mean, there was nothing that's, like you stated earlier, Judge, there was nothing in the original stipulation. I mean,
well, assume that and tell me what is a case that this court has had in characterizing a different pot of money that did not previously go toward regular maintenance of expenses?
I think the most analogous investment strategy case is Milenovich, where it was just because you classified it this way and did a tax planning investment strategy this way doesn't take it outside the scope. I think that's probably the closest case I can think of. I mean, we have, a lot of cases that talk about just the breadth of it, cases like Robinson and Thiel that talk about, vested stock options that have never been cashed in. We have those cases. We have, if you read between the lines on the Jenkins case, which was a 1031 property exchange, they only excluded the $7 million of real estate value. They specifically only excluded it because it hadn't been included before as consideration of income when the parties did it, which, I mean, this court clearly said, but for that, we would have probably included the fact you had $7 million of assets in it. All of our case law includes attributing, definitely for spousal maintenance purposes, we have tons of case law that talks about attributing a reasonable rate of return to investments and even hard assets, cases like Wisner and these things. They talk about going through and attributing a reasonable rate of return to these type of assets. Again, this is so voluntary. If this was a stock account that he was just day trading out of, there's no question that this would be included. No one would be challenging, but it's in a different creative thing that is an annuity, which is under 5A. It's also under 5A, talks about capital gains. That falls under it too.
Isn't there, I thought there was a part of this case where father was paying for education and medical and all of these things that would go into that question of what amount is proper for the best interest.
And I think that's part two.
That was outside the definition of whatever, gross income. Do we consider that?
I think, again, in part two.
How do we not?
But I think, again, that goes into what is the need of the child. You start with resources. That is the second part, where what does mother need? If, let's say, it was a situation where the father had given all the kids credit cards and bought them all cars and paid their car insurance, then okay, that would go into those issues. But that's part two of the analysis, what the need is. We have an error in part one, which is what is the court's actual finding related to his resources. That's where we're saying the error is, and we're saying that you can't get to part two when there's such a huge error in part one, which took his income down by 2/3 versus what the court-appointed expert says. And if you have another question, I got like 5 seconds. So
you can reserve 10 seconds for rebuttal. How's that?
Thank you.
Thank you. Counsel.
Good morning. Kathy Sandweiss for the appellee, Mr. Bergevin. It's not resources. Appellant keeps using the word resources and stating that what are the available resources, but this is an issue of simple statutory construction. We can just go to this statute, go to the guidelines, section 5, and it doesn't use the word resources.
But the actual statute does. 320 subsection D2 is that the court should take into account the financial resources and needs.
Correct, Judge, and then refers to what are the guidelines that the Supreme Court has developed, and those guidelines specifically refer to income, gross. The title of Section 5 of the guidelines is determination of the gross income of the parties. Okay, so let's look at it a different way. Let's say you go to a bank for a loan on a business, and the bank is going to look at what income is available to make your loan payment. So you might give a balance sheet, okay, that's going to show your net assets. You're going to show you've got a house, and let's say you bought the house 12 years ago for $200,000, and now the house has grown because this is Phoenix in 2022, and now the house is worth $800,000. Well, the bank is not going to expect you to sell that house to pay off to make your payments on this business loan. The bank is going to look at what is your regular income in order to make payments on this loan. Now, if you own this house and it was $200,000 and now it's worth $800,000, and let's say you own it free and clear, and now you're renting it out, let's say, for $50,000 a year, and you're receiving rental payments. Well, that might be considered income, probably would be considered income. But the fact that it has grown in value is not part of these guidelines. So we're not just looking at
Counsel, I think I see what you're saying, but the guideline itself says that capital gains are to be included as part of the income. So your analogy is kind of not lining up with what's in the guideline.
But the guideline then says income from any source which is not continuing or recurring in nature. So if you yes, of course, if you cash in, if you sell your stock, if you sell your house, you're going to incur capital gains. But
So
if,
are the interest accruals on father's annuity, are they not regular?
no, it's growth. Okay, so
So you're saying that he is not receiving an annual rate of interest that's added to the corpus that he has in this annuity. That seems to be inconsistent with what the testimony was.
it is being added, but there's no rule, there's no case, there's nothing in the guidelines that would require a party to take withdrawals that require a penalty. Remember what the testimony was. There's a 10% penalty. Okay, so there's nothing in the statute, there's nothing in the law, there's nothing in the guidelines that require parties to cash in a retirement account and pay a penalty. And to the contrary, this is federal law, federal tax law. You're not permitted before age 59 and a half to cash in or to take these withdrawals. If you do, you're subject to a penalty. So
that's a little bit different as I see it. So there's two concepts that seem to be melding in what you're saying. So one is you cannot, thou shalt not, so it's completely unavailable. And then there's you can, but you have to pay 10% to do so. So is that not an investment choice?
but it's a choice that's permitted. We are permitted to have retirement accounts. There is nothing in any of the cases cited by Mr. Berkshire, in any of the cases that any of us know of, that require you to not invest your money in order to pay child support, that require you to pay a penalty to pull it out. Remember, the testimony was, this is a life insurance product, okay? And even if you look at a trial exhibit 260, even Mr. Kennedy specifically said the money was taken out. We, on page, this would be Bates stamp 2139, and there's a section called pension and annuities, where there's a reference to receiving distributions from the annuity held at Sunset Life. We understand much of the money received was used to infuse into Terra Graphics. And then Mr. Kennedy cites Section 5 of the guidelines, income from any source which is not continuing or recurring need not necessarily be deemed gross income for child support purposes. As such, because it was basically shifted from one investment to another and could be considered non-recurring, we remove the taxable annuity income in determining income for support purposes. And so, to get to Judge Weidenschweig's point about may, that's right, it's discretionary. And remember, the standard of review on child support is abuse of discretion. And this judge determined that the annual growth, and remember, we're talking then about growth. We're not talking about pulling out these two withdrawals in 2017, 2018, because that's not what Mr. Kennedy was talking about. He then later talked about the growth. Later on in this exhibit, in his report, he talked about just sort of inferring that growth. But the trial court found the annual growth of father's annuity was not a continuing or recurring source of income and should be treated like any other retirement account and not considered part of his gross income for purposes of child support.
So your argument, counsel, is that there's $500,000 that's getting added to this corpus every year, and because he has chosen this investment vehicle that would put it behind a 10% firewall, a penalty of 10%, that notwithstanding, it regularly accrues this growth, as you've characterized it, that should not be included as income.
But it's not part of his income. When you look at what the rule says, the guideline says, and when you look at what is permitted under the guideline, that it's not a regular...
Let's go to those guidelines. And Judge Weidenschweig pointed out, it says gross income includes income from any source. And as Mr. Berkshire pointed out, that appears directive. And then it says, and may include, but is not limited to, and then gives a big long list. And included in there is the word annuities. Not qualified, just annuities. What are we to make of that?
Right. There's different kinds of annuities. So one type of annuity that might be included that some of the cases talk about would be, for example, if someone was in a personal injury accident and received $10 million and then received the money as an annuity in a regular, recurring, continuing monthly payment. And there are cases that say, okay, that would be included as part of income. And when you look at even the cases that are cited in the reply, the Hetherington case. So the reply focuses on this issue of employer contributions. But when you look at the reason why, and you focus then again on the requirements of Cummings, is this money that is available to make household payments? And so in Hetherington, the husband was receiving employer contributions to a 401k, health insurance, disability insurance, and the mother was a nurse who was self-employed and she had to make these payments herself. And her argument was, well, this would be money that would otherwise be available for use in the family for expenditures. And so that was the distinction. And in the other cases cited in the reply, that's also a distinction. It's a regular monthly payment in some manner, including by whether an employer is making that payment to you, and then you don't have to make the payment yourself.
Isn't the exercise just to figure out how deep a well, how much money is there to pay the expenses of the child? I mean, so my understanding is your client twice tapped this protected annuity that is on penalty of whatever. So presumably he had penalties those two times, but he made a decision that, cost-benefit analysis. Why can't we make the same in the child's best interest if dad twice made that decision in his own best interest?
Well, Mr. Kennedy's report points out correctly that the money was used to improve cash flow in Terra Graphics, so it was for that specific purpose.
So that's more important than a kid's best interest?
Well, I know we don't like
business success, but if dad has made that very decision in his mind twice, an economic decision, right? We agree with that. How is it untouchable suddenly when we get into the child support space?
Well, I know we don't like to use the phrase slippery slope, but it is, Your Honor. Are we then going to require in this state that any one of us tap into our 401ks or our IRAs or any of our allowable retirement accounts, and we're going to force people to withdraw some amount, what amount, the amount that it grows, the amount by which it grows every year, pay a penalty if, for people who are not yet 59 and a half, you have to pay a penalty, tap into that account in order to pay child support. It's a concept that's not written into the guidelines, and it would certainly be a new concept in Arizona. None of these cases appellant has been talking about would require parties to do that, to tap into perfectly allowable retirement accounts. And again, the testimony was that that's what this is.
I'm not saying require. I mean, let's break it up artificially. Let's try to come up with how much money is available. Is it do you agree that it's sort of a two-part inquiry, that we first talk income and then we talk best interest of the child?
Well, we talk income in order to get to what is the amount in the guidelines, and then should there be an upward deviation, correct? But, I mean, when you just look at the guidelines, it doesn't, this specific set of guidelines in the schedule doesn't really refer to best interest. The statute then does.
It's all about best interest, right? That's why we're here today, that's why this law exists, right?
Right.
And so, isn't that what controls rather than where the money was placed, what penalties might be incurred, what costs, opportunity, and otherwise might be incurred? Aren't we really, and I'm not saying this child's best interest isn't more than amply covered, but I'm saying, isn't that the main focus of the court?
Okay, but then if you look at the Nash case, I mean, I guess the question is, does the child need a pony? Or any of these cases about best interest. I mean, we're still talking about 3,000.
To kind of just join into this discussion about the best interest, we were talking about earlier if this is a two-step process, and it's at the best, if I'm understanding correctly, it's at the best interest step where, as Judge Coffey pointed out, mother bore the burden of establishing what was in the child's best interest. So when this court on appeal is confronted with findings and conclusions from the trial court as to an amount that was in the child's best interest, what is our job as per that first step when, as Judge Weinsweig points out, the overarching concern is the best interest?
Thank you, Judge Perkins. Yeah, that's correct. And again, Judge Coffey was there to assess the parties' credibility, to determine within his discretion what was the best interest of the parties, what's the best interest of the children, what is the gross income. And as the court has pointed out, this father is paying not only now $3,000 a month, but also I believe it's $26,000 a year for private school, all of health insurance, all of the co-pays, travel expenses, and so there is no basis to suggest that this award is anything less than in the best interest of this child. And so if that is the sole inquiry, we're not even talking about the annuity, there is nothing in this record to suggest that the best interest of the child was not considered, and it was fully within the court's discretion to enter this award. Does the court have any more questions? If not, then I would ask that this award be affirmed in its entirety. Thank you.
Thank you for your argument.
Take my 10 seconds. The 10% penalty is, I think, always been a misnomer here, because if you take the 10% penalty plus a long-term capital gain rate, it's actually lower than a normal income tax rate on income. So saying just because there's a penalty somehow outside the scope, you could actually be paying less taxes on this than we all do on our wages. So court can consider that, but it's not a default, oh, there might be a penalty, we don't touch it. That was his choice of investment vehicle. All of this was his choice.
Thank you, counsel, and thank you both for your arguments. We will take it under advisement and have a nice job. We'll have a decision out in due course.